Thank you.
Mr. Wheeler, Mr. Sussman, it's nice to see both of you today.
Thank you. Honored to be here.
Will you please the court? I'm Elizabeth Wheeler here on behalf of the appellant for my wife. And I'd like to reserve 4 minutes of my time for them. I'd like to use my time this morning to focus on certain issues of concern, subject to the court's redirection to other issues of greater interest to you, relying on our briefing for all other arguments. We are challenging a supplemental order on attorney's fees entered on October 29, 2024, which awarded only $15,265 of the fee request. Ms. DeCosta had recovered an additional $675 in the first order on fees. That was the time for the husband's lack of compliance. So together, she has recovered $15,940 of her request of $73,763. She has recovered approximately 21% of the fees and costs that she requested. How did she lose $57,823 of her fee and cost request, or 78% of what she was seeking? And then I would also point out that her testimony addresses additional costs that are not encompassed in this analysis. She testifies without dispute that she's paid another $4,200 in costs to the vocational evaluator, and she testifies that she's paid $5,000 to a child custody evaluator, Dr. Broder. So the situation is even worse if you consider those additional sums that the record would support. At the fee hearing, the court received evidence from the former wife, which we believe satisfied her burden of proof. Ms. King's affidavit of fees and costs comes in by stipulation as former husband's exhibit 4. Ms. King testifies, and she states without dispute that her fees and charges were reasonable and necessary for the wife's effective representation, and that's at record page 517. Her deposition testimony also comes into evidence as former husband's 13, which provides additional information. Meanwhile, the former husband did not challenge any specific time entries or cost components, as he bore the burden to do under the cases cited in our brief, including, of course, Syntex Rooney Construction Company and Fleming versus Fleming.
Here, but I think Mr. Sessions does dispute, based on the former wife's attorney's testimony, I made a few miscellaneous reductions, courtesy discounts, etc., and it's reduced to $152.5. Those were not articulated or described or specified.
She addresses that in her deposition testimony. That discrepancy that he points out, it's less than $3,000, but she says that's due to the write-offs, the courtesy write-offs that she's made.
And he seems to make a point that in the deposition, the former wife's attorney seemed to agree that it was only $10,000 owed.
In
That she
fees.
didn't owe $73,000 in fees and costs or $52,000 in fees. She had already paid up to what's left. Bank balance was $2,000. Is that true?
Your Honor, I believe this distinction is she states that's what that is owed in fees. Bearing in mind, of course, that additional costs have been paid just as a conduit through Ms. King's trust account.
Just because she paid the fees up to that amount, that doesn't disqualify her from being entitled to fees, does it?
No, Your
Just
Honor.
because you paid them.
No, because she's consumed marital assets to do that. She's incurred credit card debt. She's spent her share of the distribution of the marital home, and she's taken $25,000 out of her retirement account. Meanwhile, we know that Dr. Blissett is funding his litigation through his earnings from his.
Well, some of the cost testimony, I mean, early on before the hearing, when the court was doing housekeeping, I think that a couple of those affidavits were excluded for hearsay, correct or not?
The former wife's attorney's affidavit comes.
Well, those two attorneys, I get that. I think that you or your Ms. Lowe agreed.
That is correct.
But what I'm talking about is, I think it's CPA's affidavit or something.
Yes, Your
Your affidavit concerning cost seems to have been excluded based on hearsay. Is that true?
That is true. And our problem with that is that there was never an objection to costs that would necessitate an evidentiary hearing. I wanted to bring that.
But you're arguing that that was an error here. You
We don't know if any costs were awarded. This
know,
was
but
award.
it was excluded from hearsay below, but I don't know that you put that up on appeal. Whether you're arguing that that decision to exclude it was error and it's before us.
That is, we have not addressed the
Okay.
exclusion of that affidavit. Because, I mean, if you have not objected to costs, then do you even get to the evidentiary portion of a hearing? Costs properly can be determined by the trial judge based upon the trial judge's familiarity with those issues and the trial judge's review of the record before, as I understand it. And we do have a citation to that effect. That, of course, is part of the costs that are addressed in this court's opinions in Lafferty and Catalano versus Catalano. It is the objection to the expert's fees, not the claim for the fees, that triggers the need for an evidentiary hearing. That's Catalano at 1148. And if there is no objection to the costs, then really, why are we there even needing to talk about bringing the accountant to come testify about the costs?
Well, I'm trying to follow your argument because apparently Mr. Sessions did object based on hearsay and that affidavit that established an itemized list of costs for that account was not admitted.
Your Honor, I understand that.
Appeal.
I understand that, but
Trying to figure out why you're arguing in front of us when you didn't preserve it.
well, Your Honor, the issue that when trial counsel puts in the record the list of costs that she is seeking, the affidavit of the accountant, there is no objection by the opposing party. They don't do any specific objections to any specific items, even in the way of attorney's fees or in the way of costs. So if you don't object, if you don't raise some issue, I don't think you're entitled to any of these costs. Does that require an evidentiary hearing to establish costs? You know, as I read Catalano, the court is entitled to just evaluate the list of costs as included in the record now, because she did file that with the court. The notice of filing of the affidavit of Mr. Dotson. What I wanted to also point out, you know, the trial court says that an argument has been made about block billing, but I went through the record to try to find, well, where is this argument? I wanted to examine how it was raised at the trial level. I do not find it. It's not in Mr. Sessoms' response to the motion for fees. It is not in the transcript of the hearing on April the 29th. If you do a word search for the term block billing, you find no reference to block billing. You find no reference to bulk billing. So there is no specific objection on that basis that I could find in this record. What I also wanted to point out as you go through and study this, the authorities carefully, we're of course talking about the Syntex Rooney Construction versus Martin County, which says that the opponent of the fee award must point out with specificity the hours which should be deducted. They cite a federal decision, Norman versus Housing Authority out of the 11th Circuit, which adds that the opponent must produce evidence of unreasonable and unnecessary attorney's fees. Mr. Sessoms presents no evidence of unreasonable or unnecessary fees or costs. The only evidence, he cross-examines Ms. King, so that doesn't provide what he needs. And he presents the testimony of Dr. Blissett, and he doesn't have any information about unreasonable or unnecessary time by Ms. King. Our starting point, the biggest problems we start with there is no analysis under Roe as to what a reasonable fee would be. We've established by stipulation that the hours that are being charged are reasonable, but the trial court never informs us what a reasonable fee would be before we get this arbitrary bottom line of $15,265, which is not even sufficient to address the cost component. Any of the cost components. Some of the costs are addressed in Ms. King's affidavit of fees and costs. She talks about the appraisal fee for the building. She talks about the court reporter fees, the service of process fees. So all of the costs are not simply Mr. Dotson's. You know, what cost, if any, did my client recover here? And we cannot tell because there is no specificity in this order. And therein lies our complaint with it. This is an order that this court cannot meaningfully review. You cannot discern from the record before you how these specific numbers were seized upon by the trial court versus the total requested, which was $73,763. I want to just very briefly focus on, of course, block billing as discussed in Spanicos. Block billing does not warrant a reduction where the entries are so well detailed and so informative that the lack of segregation of the time for a related task does not interfere with the court's assessment as to reasonableness of the time spent. And that certainly seems to be the case here. Again, we go back to what argument was made about block billing, and I don't find it. And certainly at the evidentiary hearing. The final thing I wanted to point out in my time was the issue we're raising about the net income not being accurate. That is for the purpose of showing that the unexplained installment payment plan is not reasonable. $500 a month, they will pay over, Dr. Blissett will pay over a period of 30 and a half months. My client would still have a deficit of $2,500. He would still have a surplus of $2,500 under the court's findings. But then we go back to the issue that case law is very clear that you make that assessment at the time of judgment, not at some future point. And I'd like to point out just a few points there. The attorney fee affidavit, the financial affidavit that the court relies upon is dated August the 17th, 2023, which is before child support is established on October 11, 2023. Child support is established based on the income that Mr. Dotson testified to. And that is shown in former wife's exhibit B in the record. I also wanted to point out that the financial affidavit is not complete. It doesn't have any listing of assets on there. And we know that attorney's fees cannot be determined solely on income alone. It does take an evaluation of the financial position, the full financial position of both parties. But Dr. Blissett has not supplied that on this new date he has selected.
Ms. Wheeler, I have a couple of questions for you. One, if we were to reverse on this,
Yes, Your Honor.
do you agree that the trial court would be limited to the record as it currently exists?
Your Honor, I do agree with that, but then you go back to, well, what evidence was presented by the opposing party? What evidence can the trial court rely upon? Argument is not evidence.
The findings aspect.
Yes,
But in terms of the evidence, there was no ruling by the trial court as far as exclusion of evidence that would require us to send it back and say, or needs to take additional evidence.
I agree with that, Your Honor.
The second question I had to do with the Julia versus Ramos-Baez case from the 6th District Court of Appeal. They certified conflict with a number of districts. I'm not certain if we're actually in conflict because our court has said essentially that if there are no written findings, but there's a transcript and there are findings in the transcript, that would potentially cure any error. It seems like Mr. Sessoms has argued that Julia case goes a bit further to say, well, it's not fundamental error and distorted. So I wanted to get your take on that because I don't think you really addressed it in detail in the reply.
Yes, Your Honor. Certainly, I don't think there are any findings at verbal findings at the final hearing, at the evidentiary hearing on attorney's fees. There's no.
I guess that's really my question. If we are satisfied that there are no findings sufficient to explain what the court did and allowing us to make meaningful review, Does the Julia case say something different that, because even in their footnote, they refer to, let me make sure I'm saying it correctly, because I don't want to misquote it. They said that, the whole, neither section 6116 Florida statutes or Roe require any findings to be made in writing. And so it seems to me that I'm not quite sure that they're actually in conflict with us, even though they're certified conflict. And so I wanted to give you a chance to address that, and the post-district assessments will have that same chance.
I would agree with your assessment, Your Honor. This court has said that as well, that the findings can be verbal on the record, but there are no verbal findings on the record in this case. So, we get back to the issue. This is an unexplained award that at a minimum, it has to be reversed for additional factual findings. And if the court pursues the path that it's taken, we may have to come back for another appeal because there is no evidence as to block billing being a problem. There is no evidence of certainly any contentious behavior. The term that the court used was not even that. It's like unnecessary behavior from the former wife that would have increased her fees to a point that they should be reduced. Thank you, Your Honor. Thank you.
Okay, please, the court. I think the last issue that was addressed with counsel would be the issue I would address first. I think the Julia court lays out the trail we're attempting to follow, which is that Judge Davis, in his concurrence in the Harris case, stated very specifically when he traced it back that there's not really a basis in the Second District Court of Appeals decisions when you really analyze it for finding that attorney's fees should be treated any differently than alimony or equitable distribution in terms of written findings.
Well, that's different if there's no findings at all, correct?
Well, there are findings. They're not
Where? Here?
here. There are.
This is,
Well,
this woefully lacks findings.
there's a reasonable hourly rate.
Through money. I'm glad to.
Say again.
I'm glad to. This judge does not describe what block billing, what particular block billing.
There's no question about that.
Absolutely.
Yeah.
This judge does not describe the contentious or unnecessary behavior whatsoever.
Not with specificity.
Not. And then the finding of $15,000, she doesn't make any findings as to the reasonable amount of fees that the wife is entitled to. She simply gives her $15,000. You agree that the wife's attorney's $300 to your credit is reasonable hourly rate, right?
I stipulated.
And she asked for 152 hours. What happens is this judge, without any findings whatsoever as to the number of reasonable hours and the amount of fees, which I did the math, she reduced it to 50.8 hours to the former wife's attorney, which excluded 101.2 hours without any specified reason whatsoever.
There's no question.
It needs to go back.
Well, that's the issue.
But see, Julia, here's what I have a problem with Julia.
Okay.
It's dicta.
It what?
It's dicta. Because the 6 DCA holds there's no transcript, therefore we cannot do appellate review. But yet Judge Wise gratuitously says, okay, but let's look at whether findings are required. When the holding in the case is there's no transcript, we can't review it.
Okay.
But let me tell you my opinion on findings.
Okay.
So I don't put any value on that at all, because how are we supposed to review a case if there's no oral findings or written findings? We can't.
The question is whether you're required to reverse them when there are findings, and the judge clearly read the 23-page or the 23-page fee affidavit.
I understand she read it, but she didn't recite it in the order. That's the problem.
There's no question she didn't recite it in the order.
Doesn't,
but there's-
she read it. She doesn't say, Mr. Sessom.
I'm not arguing with you. I've already conceded the point because it's open and obvious. I'm asking you to consider something different.
Did the court say she's only entitled to 50 hours at $300? No. Did the court say why she's only entitled to 50.2 hours at $300? No.
There were reasons, but it was not with
Okay,
specificity.
did the court say that the fact that she paid up to $10,000, you're a good lawyer.
Thank
You're
you.
a good lawyer.
Thank you.
The fact that she only owed $10,000 entitles her to $15,000. No.
No.
So we can't really analyze this at an appellate court and give direction to a trial court based on this order.
But are you required to have specificity in findings is the issue?
Clark has repeatedly stated, we need sufficient findings to provide meaningful review.
If the court's reaffirming its prior decisions in the face of what Judge Davis analyzed with specificity, to say that that's fundamental error if there's not written findings, it's end of discussion. I would agree with that. However, I would submit to you that that's not what Julia points towards and really
Julia, and this is why I wanted to ask this question. If I remember correctly, Julia had a transcript. And then Julia basically went out in what I would consider dicta and say, well, the second district and other districts have said that it's fundamentally erroneous, even if there is no transcript. And Esau and some other cases say, well, in the absence of transcript, we can't tell what happened, but it's the appellant's failure to provide a transcript. So that might be where, I think that's where they're trying to assert conflict, but that was really dicta in Julia, wasn't it?
fair enough. I'm not disagreeing with that. You're still left with the issue, which we,
With certain findings. So the question is whether those findings are adequate to provide a meaningful review.
you're left with a statute that talks about harmless error. You left with the fact that the legislature has revised the alimony and equitable distribution statutes to specifically require written findings, but not 6116 that we're traveling on here. There's nothing in 6116 that requires written findings. There is a harmless error statute. There's no reason why it would not apply here, as Judge Davis ably argued in his concurrence. We're asking you to consider that. Trial courts should be.
We're happy to consider your argument.
No, I know.
Don't worry about that part.
I meant it is a term of art. We're asking you to utilize that because this court clearly grappled with, we can start at the final judgment and talk about all the bad things that the judge said about both parties. We can talk about all the issues. Ms. King's testimony is 3.5 pages. That's it. She testifies for about 2 minutes. She doesn't give any specificity. She doesn't sustain her burden of showing that these fees are reasonable, except glibly saying that they are.
Well, but there's a pretty long affidavit, you would agree, in the record.
3 pages. The court said he read it.
Sorry?
23 pages. The court specifically said it read it.
I
And
understand that, but she was asking for $17,000, $73,000, 52 of which was fees, and the court gave her 15. The court can do that. They just need to tell us why. Rome required that.
if you're requiring written findings,
Hold on, let me finish. Because if you were on the other side, you'd be screaming to like me. Okay, let's say, Mr. Sessoms, you charge $300 an hour. And you put 152 hours in there, and you don't get 50, and the judge never says why. Are you gonna sit here and tell me that complies with Roe?
if your decisions are what the second DCA has said in the past without analyzing the harmless error statute, you're correct. I've said that. I'm just repeating myself. So you are correct that other decisions from the second DCA imply that that's fundamental error not to do that. I'm saying to you, there's no reason of law why it should be so based on the harmless error statute. If it is, then you're right. You need to remand and you need to tell Judge Curley exactly what she needs to do, which is to go give us some written findings, not have another hearing to answer Judge Silverman's question.
That's where we're going.
Okay.
But see, I think you've been here long enough and done enough film law to know there's equity in family law. So there's fairness. So what you're arguing may not be fair.
Okay, she's asked for $73,000, we got 15.
Well, two lawyers didn't show up. There's no real proof of costs.
Right.
And she can't say what is clerical and what's not. She can't say how this contentious litigation affected her fees. There's a lot of things she couldn't sustain her burden, in my opinion. Her fee affidavit is inconsistent.
Let me maybe cut to what I think is coming to the chase.
Yes.
What did the trial court determine was the source of the award?
What did the trial court determine was this?
How did the trial court come up with the number that she came up with?
Well, we can't say with specificity, as I just went through with Judge Sleep.
So how do we determine if that award is supported by the evidence that the trial court reviewed? Because I'm not sure if the judge said, I'm just going to cut 70% out, whatever the percentages are, I don't remember. But how did the court arrive at the specific number that we're now reviewing?
Who can say? All we can say is what she specifically articulated were her concerns. So she specifically articulated certain concerns. If it's a discretionary decision, which I'm submitting it would be, because it's not a miscarriage of justice, it's harmless error. At best, it is a decision trial courts face all the time. And she specifically went through the affidavit and she specifically had certain concerns. But if she needs to time down, then tell her to go back and tell us how you came to this number. And then we'll know.
No, but the question that I think we're struggling with is you're suggesting that's not necessary.
I'm suggesting that the harmless error statute would suggest that it's not necessary. I recognize the prior decisions from the Second District Court of Appeal, but I read Judge, when I sat down and looked at this, I said, how are we going to deal with this? There's an issue here. Then I read Judge Davis's concurrence and I said, oh, wait a minute. The 60CA has done this. I recognize that you believe that it's dicta, and I'm not arguing.
Is it dicta? Because
I'm not arguing that.
But they certified conflict based on what appears to be dicta.
Who knows why? I remember when I had the Browning versus Poirier decision that I have in there, that I had a Yates versus Ball Supreme Court decision. I thought it was a home run. And Judge Kennedy, who went to my son's wedding, recused himself, and he had a second DCA opinion that was in our favor too. The first question they asked us is, if we reverse, what should we do? And I said, you can't reverse. It's stare decisis. And they laughed. So I recognize that courts do different things based on how you perceive it. And I'm saying, I just want you to carefully look at the harmless error statute and look at Julia and look at Judge Davis's concurrence, because it makes sense to me. And I'm saying this specifically.
How does concurrence resolve the question in this case? Because we do have a transcript. We do have an order. We have a record. And I'm not sure we can determine whether the trial court appropriately exercised discretion or flipped a coin.
Well, you're only
accuse the judge of flipping a coin, but we don't know how the number was arrived at. And so do we just say, well, the court might have done it because there were these disputes as to what the block billing constituted and what the hours reflected in the block billing, whether they were justly charged. Is that what we're supposed to do in this case in light of Roe and the progeny of Roe?
You would say that it is a discretionary decision of the trial judge. And in addition, that Ms. King did not satisfy her burden because she couldn't answer the specific questions about the problems that I've articulated: the clerical time, the excessive litigation, the block billing, all of these things that we've articulated in our.
Was there an expert on your side that said these were all unreasonable?
Didn't need one. Didn't have one. Didn't need one.
I mean, Mr. Sessions, you and Ms. Wheeler have been around a long time.
Long time.
And maybe we've all been around. Yeah, we've all been
It
around a
appears
long
to
time.
be so.
But typically, the way it's teed up is there's competing evidence. And, in that circumstance, we might very well say there's a disputed issue of fact. There's competing evidence. Judge chose one versus the other. We don't have that here.
What we do is that it's encapsulated in Ms. King's responses of, I don't know. I can't tell you. Is there clerical time in here? It's on its face. Can you tell me how much clerical time is in here? No, I can't do that. Can you tell me how much you spent on this excessive litigation? No, I can't do that. Can you segregate out how the time would be different if you allocated these tasks to block those? No, I can't do that.
Segregate out those answers.
Did I?
No, can we, on appeal,
That's the point.
segregate out those answers and say, that, okay, now we see the judge eliminated all this. And
No.
I'm not sure we can figure that out.
I'm not sure we can figure that out. I'm not sure how Judge Curley is going to deal with that when we go back, if we go back. So that's an issue. That's part of what my point is that,
But you're, on behalf of your client, cross-examination was undertaken. And
was what?
cross-examination was undertaken.
Yes,
And there were certain answers that were unsatisfactory to your side and presumably to the judge. But again, if we take all that cross-examination, I still don't see how we come up with a number that the judge awarded.
well, then she'll need to articulate that if you reverse and remand for her to articulate the findings. She'll have to tell us that.
And it seems to me the judge might very well be able to do that. And that's why I asked Ms. Wheeler, is there any reason for us to, if we reverse, is there any reason for us to say, Judge, you got to reopen this, take more evidence? I think the answer is no, unless the judge deems it necessary for some reason. And even in that circumstance, I think we might all be living with the record we have, which is maybe more findings to explain how she got to that number.
What I think she would say is, these are the only things that I can say are reasonable. And here's how I came up with it. And it's a fairly academic task for her to do. Usually we don't even,
If it was academic in the sense of just adding up some numbers, I suspect your brief would have said, here's how she came up with it. You eliminate this, 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 and this, and you're left with X.
you're totally correct. The only numbers I can come up with is Judge Sleet's calculation, which he came up with quite handily. So,
Calculate. I have a question.
yes, sir.
You made an objection initially in the fee hearing as to the admission of the experts affidavits, correct?
I heard you say that. I don't remember it specifically, but I heard you say it.
Let's assume you did.
Okay.
And she excluded that. And those would have been the affidavits that established the cost.
Right.
Now, somewhere around $20,000, that neighborhood. There's no other testimony about cost thereafter. Are you saying that based on that ruling excluding the affidavits related to cost, the $20,000 cost, that forecloses that issue?
Okay, so,
Well, I'm asking you.
no, I agree. It does foreclose it. So there was no effort to overturn it, as you indicated it. There was no,
Yeah, it's not before us.
yeah.
Okay. Well, what do you say to this Wheeler? I was trying to follow the argument in terms of it, despite a ruling that those affidavits established in cost, she says the court still can consider that as what's reasonable.
I don't know how.
Okay.
I think we've grappled with the main issue. I have lots of other things to say, but I think we've dealt with what the court's focused on. So I'll sit down. Thank you for your attention.
Mr. Ms. Miller, you've got 4 minutes of rebuttal time.
Thank you, Your Honor. Very briefly, to respond to Judge Sleet's question, all the evidence concerning the cost was not excluded because on page 67 of the record, the final page of Ms. King's affidavit, she outlines costs. She outlines the court reporter. She outlines the evaluation of the building, the commercial building. She outlines the payment to SE Forensic Accountants LLC, and that's at record page 67. The other point I wanted to respond to specifically, Mr. Sessoms misstated when he said that Ms. King could not segregate out any misconduct of the wife. And that is because she testified both in her deposition and distinctly at the hearing that she had observed no behavior of Ms. Jakoska which had increased her attorney's fees or which warranted any kind of reduction. And that is at R 398 and then at R 525. 398 is the deposition testimony, 525 is the testimony where she repeats that at the
Judge Bonner's final judgment was very clear about both parties to the point that they even shouldn't be parenting this child. So this judge, I can't remember the name, sorry, relied upon those findings in the final judgment. In terms of something that's contentious and unnecessary litigation. Right?
I don't think anything linked that up to specific time entries. Yeah, and as I understand, you must do when you're
But
making.
Ms. King responded to your issues. Mr. King responded that the child support issue had been resolved without court intervention. Therefore, that was not an issue of contention, which the court can consider, correct?
That is correct.
Well, if he wants to remand it, I think I'm pretty clear on remanding in terms of fees and specificity, but how about these costs? Because I believe there was a ruling that they were excluded based on hearsay. Now you're telling me that they were subsequently testified to.
I just want to be clear so I'm not confusing
Yeah.
that issue. Mr. Dotson's fee affidavit was excluded as hearsay. There's no doubt about that. But Mr. Dotson,
Yeah.
he's a CPA. He is SE Forensic Accountants. But his information as to the payments that Ms. King has made, it's all passing through her trust account. She summarizes that on page 67 of the record in her fee affidavit. And so this would be a situation if you feel, well, there is a case law that says that if some evidence has been presented, which is it's in the record because this came in by stipulation, but, then you can remand for further.
But I'm comparing
Take it.
that's from the accountant's affidavit, which sets forth based on his accounting background.
Right.
What is reasonable, it was expended in this case, his time and his fees versus Ms. King, the former attorney, simply saying, yeah, we paid it.
And Your Honor, I guess if Mr. Sessoms had objected to any elements of the cost, had he objected to that, then there would have been an evidentiary hearing necessary with adequate proof offered. But he never made that objection. He never made an objection as to, quote, this block billing. So this is going to be sent back to the trial court, but she is now going to be having to parse through the 23 pages without direction from Mr. Sessoms in any particular specific objections that he made, because he didn't make any. He's trying to eliminate the fee award completely. He reiterates that many times at the trial level that an award of 0 is appropriate. So he's painting with a broad brush because a specific analysis won't get him to 0. And so, Your Honor, we believe that it is reversible and it must be remanded for further findings. Thank you.
Very good. Thank you both very much. That concludes our oral argument topic for today. We appreciate it and appreciate seeing you.
All rise.